Welcome to Better HR in 10 Minutes, where we take a question for HR and in 10 minutes or less, we discuss it from the point of view of a trainer and from the point of view of a labor and employment law attorney. I'm the trainer. I'm Rodney Klein. I have over 30 years experience as owner of my own training firm, Rodney Klein EEO Training, and with the U.S. Equal Employment Opportunity Commission.
And I'm the employment law attorney. My name is Sarah Glasser. I'm a shareholder at Lloyd Gosselin, Rochelle and Townsend in Austin, Texas. And I head up our firm's employment law practice group, where I help my business and governmental entity clients comply with the law, treat their employees fairly, and stay off the witness stand. Before we start, both Rodney and I have to say that this video includes comments made by a lawyer and an EEO consultant. It's made available for educational purposes and to give you general information and a general understanding of the law, not to provide specific legal advice. If you do have a specific legal question, you should contact an attorney who represents you.
Great. Thank you, Sarah. So the question for today is about a Supreme Court decision, Groff versus DeJoy. And there's been a lot of discussion about this. Groff decision impacted religious accommodation issues. So Sarah, what's important about that decision for HR to remember?
Yeah, Rodney, this has been such a sea change in terms of how employers look at religious accommodation because it increased the burden that employers are supposed to face or sort of undertake in order to accommodate employees who have sincerely held religious beliefs. So from a legal perspective, the change in the standard is it went from a de minimis standard. In other words, is there anything more than a very small additional cost to does the requested accommodation create a substantial increased cost? So, I don't know about you, but to me that those words mean, okay, did it cost more? But like how much more?
I always say it must be cool to be a Supreme Court justice because you just get to talk about whatever you want to talk about and you don't have to talk about what you don't. So the Supreme Court came back and said, well, the standard should be more. Well, what's more? Well, more, but not too much more, not ADA more, but just more. And since the standard was like super low and ADA is super high, that's a lot of area to cover. So as an attorney, how are you advising your clients when they come back and say, hey, we've got this religious accommodation issue, and you're trying to figure out what more is?
Great question. So I think this is a great opportunity to point out that more means different things for different people, or in this instance, different things for different clients. And so when somebody calls me and asks this question, when I'm talking to them about an ADA accommodation, I usually explain to them, look, here's where you think the standard ought to be, but I promise you the law puts it here. And I think we're getting closer to that conversation with a religious accommodation as well now.
Yeah, the one thing I think when I read through the decision myself, the one thing the court was kind of definitive about was what was not going to be considered as more was grouchy coworkers and grouchy customers, right? So if, like in that particular case, Mr. Groff could not work on Sundays because of his sincerely held religious belief, and what could not factor into undue hardship analysis was how his coworkers felt about picking up extra shifts. They were very adamant about that part. What I also thought was interesting about it was they were also very adamant that employers have an affirmative responsibility to accommodate. And I think a lot of times employers think they're just the accommodation judges, right? That you bring me an accommodation request and I tell you yes or no. And the court said, no, it's your job to actually figure this out.
Yeah. So in other words, now you need to engage in an interactive process. And if the specific accommodation that the employee has asked for is not going to work, then is there something else that can work for you? Now, there haven't been very many cases which interpret Groff, but we do have at least one in the Fifth Circuit so far. And if you are interested in reading it, it's Hebrew versus TDCJ. And in that case, the court focused almost single-handedly on the word cost. They said, okay, so you're going to raise all these safety concerns about as reasons why you cannot accommodate the employee, but what you didn't do, the evidence that you didn't put on, is how much it's going to cost you to resolve these safety concerns. And I think it would be the same with respect to what happened with Mr. Groff, which was that his coworkers didn't want to cover for him. And the court would then look at it and say, well, how much is it going to cost you to address these coworker concerns? And if the coworker concerns are something more than just, say, some animus towards the employee, but it's like you don't have coverage, what's it going to cost to get that coverage?
Right, I agree. I think that objectively speaking, I think it was really nice that the Supreme Court raised the standard. It didn't make a lot of sense to have religious accommodations out there if employers never really had to provide them. But I do think it raises a lot of questions, and we'll save this maybe for another session or another question. But I think there were also some implications with the Groff decision that the Supreme Court did not address at all. That I think makes it very difficult for employers to work with, and we'll talk about that at another time. So anyway, that's our session for today, and hope you enjoyed it. And check out our other videos. And if we can be of any help to you, please let us know.